afternoon, all the participants attending this workshop. And I see that for this workshop, we can provide a lot of useful knowledge for businesses. And we from Custom Authority, we are very privileged to get invited by IPKC and also IP Vietnam to be here to talk to you about some matters regarding custom operations and our operations at the border. And we also want to get recommendations and comment from the businesses so that we can improve our customs operations. And to start the presentation today, as assigned by the organizers, I will talk about the prevention of infringement of IP rights and control of imports and exports at the border. As you know, custom administration is one of the 6 enforcement agencies nationwide. Besides the law enforcement agencies like public security or inspectors and also market surveillance and pupils committees at different level, then custom administration, we work at the border. You can imagine that if we enforce at the border, we are the front line and also like the last, like forced to, for both imports and exports, and with the support from the rights holders and the legal representatives and other forces, then our custom, we can do our mandate at our best. You can see from the screen, we have 5 mandates. First, we develop the legal framework as an enforcement agency. Besides enforced regulations, in the last 2 days, we heard about the IP law, the degrees, and customs. We also have a circular 13 with the revision in 2020, we stipulate the procedures and process to control goods involved IPR and to protect IPRs at the border. And as an enforcers, we also need to collaborate with other competent agencies. We also work with the rights holder, and we also have international cooperation to address the IP infringement cross-border. Then we must establish the relationship with international organizations and with other countries. And you can see, and probably you are aware of the organizational structure of the customs sector. And for those who are not fully aware of that, I would like to say that General Department of Vietnam Customs GDVC, we have 3 key arms to enforce IP law, but we also have other arms like the Risk Management Department or International Cooperation Department or Vietnam Customs School and Legal Department. They also contribute to the enforcement of IP law. But right now we have 3 key arms working directly with the enforcement. First is the Risk Management Department. That is my unit. And Risk Management Department, we receive the application from the rights holder, and we also provide guidance on enforcement, and we also inspect and audit the implementation at the local level, and we also improve the work on capacity building for the local custom department, and also anti-smuggling department. They also for the enforcement agency, and they also work with us for awareness raising. And last is 35 local custom departments. And out of 35 local custom departments, we have 193 sub-departments and 20 enforcement team nationwide to be in charge of the enforcement. And at the local level, they also they are also proactive in capacity building for enforcement. And to enforce IPRs at the border. And in the morning, Miss Tao already talked about the regulations in custom laws regarding the functions and mandates of the custom authority. So we have two key mandates stipulated in legislation. First, we have the mandate to inspect goods with the indicators of IPR infringement, and we can suspect the custom clearance for goods with the suspicions of IPR infringement. And it is translated in Circular 13 for the enforcement. And so for the first mandate is to do the audit and inspection. We will do at the request of the rights holder or legal representative to conduct the suspension actions. And please bear in mind that during the enforcement, we receive some requests from businesses or representative of the rights holder sending to the custom authority, requesting custom authority to inspect the goods with this trademark, for example. And we have to give feedback to the business that if you want to apply the inspection measures, then you need to submit the complete dossiers and the content of that application. Only receive a request that please do the inspection, then we cannot do that because to inspect goods with IP rights. That is just a part of our jobs, but we also need to cover other disciplines, for example, like fraudulent goods or tax evasion or smuggle goods. So besides the protection of IPRs at the border, we also have to cover other mandates. That's why please understand that when you want us to help you in a quick manner, then you need to submit the sufficient documents. And for the suspension, um, in the OIP law, custom authority is allowed to suspend at the request of the rights holder. With the revised IP law, custom, we have the mandate to proactively suspend the custom clearance process. And like Ms. Tao said, like in the law and decree stipulates that like custom authority, we need the clear evidence, and it's only applicable for the counterfeit IPR goods. Even though we are given a new mandate and it's flexible for custom, and it somehow, like Mr. Chien said, it can facilitate businesses, and businesses can be rest assured that if their trademark is protected, and if custom we have enough evidence, then it will not take time for you to request for the suspensions, and then our custom authority we can proactively suspend the clearance of the shipment. However, if solely based on the document dossiers, then custom we do not solid grounds for that. To do that, we should have the intelligence network, and we should have the skills of information analysis, because you know that together with this right, we also have the obligation. We have to trade off the obligation, because if we suspend the wrong shipment, then we have to pay compensation for the importers. And during the suspension, any damage caused by suspension, then we need to compensate for the importers. And that's why the frontline custom officers they are hesitant to do this. And we are also aware that to do that, we it's required that, and it should be in the electronic form. With this approach, custom sector, we are developing the electronic database, and we are developing a smart custom, and then we embed the monitoring and inspection of IPR goods in this. And we also need the intelligence network, and we need to receive the e-manifest. We need the advanced information to make sure then we can confident in enforce this proactive suspension. And the objects can be protected by custom, and it is stipulated in the IP law. First is the copyright and relevant rights. Second is the industrial property and rights to the plant varieties. And we can see that the object here mostly like 90% of them are trademarks, and some industrial design, and some relates to GI for fruits. Very few cases, one or two cases. That is from our statistics. And lately, there are some law firms. They discuss with us that whether we should have the protection of copyright. Copyright is one of the subject that can be protected at the border by custom. And what about the scope? The scope, we control imports, exports, and transited goods. All this type of goods are subject to the supervision from and inspection from custom. And we also have the exclusion. We also have the exemption for non-commercial goods like humanitarian aid goods, movable assets, or like gifts and donations, and transited goods. They are not the subjects that can be suspended. Transited goods is still one of the applicable subject, and subject to the supervision of customs for different purposes. For example, like for goods fraudulent or tax evasion, if we discover the infringement of IPR, we still use our laws for enforcement. And we have heard about this in the last 2 days. Going back to the key story, And probably law firms you might be interested is that the dossier you have to submit to the custom authority, and it's under circular 13. There are 6 documents that are compulsory, and there are the additional documents. The more documents you can provide, the better it is for custom officers to identify whether it's the counterfeit goods or that is the goods infringing IPR. First is the application form, and second, you should have the protection title. Third is the detailed description of goods infringing IPR, and and also the images of the authentic goods. Fourth is list of importers or legal importers and manufacturers or the authorized entities. And if you have the goods you suspect that it can be the infringement, you can provide as well. And if you have the clear evidence of infringement, then you are encouraged to add to the dossier, because we can have the legal basis to know whether that importers had infringement in the past or not. So when they lodge the entry, uh, then it would be helpful for us to identify whether there's an infringement or we need to suspect the consignment or not. Um, and fifth is the authorization documents. In the morning, one lady asked about the evidence of authorization. So this document is to understand the scope of authorization from the rights holder to you, whether they are relevant to our custom operation or not. And based on the scope of authorization, then we can make the consideration. And this authorization document should be notarized and have to be legalized. And lastly is the fee payment voucher. And in 2015, for the under the circular, it was free of charge. But later, with the revised circular, for each application, then they have to pay the fee of 200,000 dong or $8. And when you have these documents, please send to the custom authority and also the custom supervision department. They will make the decision whether the goods should be suspended or not. And if there's not enough grounds, then we ask the business to add on provide more supplementary documents. And we also need to explain to the applicant, in case we turn down the application, the reason why we turn down their case. And this is all stipulated in our legal documents, and you can refer to them for further information. And within 20 days, we should provide the feedback to the business after they file the application. And I have to say that we do not have the electronic database, and we use the hybrid form, like we send email to the local custom departments, and then they will be passed down to the local custom sub department, and based on that request, then they can conduct the inspection or supervision at the border. That is about the application. And to terminate the termination. So, like for each application, the statute of limitation is 2 years, and you can expand for another 2 years. However, and in these 4 years, the your protection title should be valid, and if expired before the first 2 years or the extended 2 years, then we will refer to the validity of the protection title. For example, like your protection title. So we only base on the validity of the protection title. So you have to make sure that you renew the protection title before you file the application to us, because otherwise you have to repeat the process again. So if you can renew the validity of your protection title, then we can support you in the first 2 years, or if you extend it for another 2 years, so in total it's like 4 years. And and that is about the inspection and supervision. And second is the suspension. And for the suspension application, there are 6 documents, but here we have 7 documents, and it's applicable to goods that custom do not have the written document to accept the suspensions of the consignment. And like in this case, you need to submit additional documents. So for the first 6 documents, similar to the request for the inspection and supervision. However, if you already submitted those documents, then you only need to add another application form to request for suspension, and you can make some deposit payment. Um, so in case if you haven't submitted the application for inspection and supervision, then you still can submit the application to suspend the consignment. And this is the point I would like you to be clear, so that you understand your rights and benefits. And like for custom authority, we can work with you not only prior to arrival of the goods, but during the clearance of the goods we can work with you as well. And for the deposit, uh, like how much is that? It's based on the declared value of the goods. Usually it's 20% of the declared goods. And if you haven't valuated, then you can make a deposit of 20 million dong. And this fee is to cover for the cost incurring. And for the procedures, they are similar to the procedures for inspection and supervision. But then for suspension, the procedures must be conducted fast, because the pressure on custom is huge. Because when goods arrive, we need to clear them fast. And for custom, we need to balance the needs of importers and the needs of the rights holders. Um, And in that case, we have to give the feedback to the application of suspension. After we receiving the application for suspension, then we need to notify and make the decision. And what we do next, we And during the suspension, what do we do? And we need to take the sample to work with the goods owners and the right holder to get the sample so that we can send the request for examination if needed. And and if the rights holders they have the ground to confirm that the goods is infringed, then we can process right away. But if there's a dispute, then we have to request for examination, and then we need to take sample and send to the IP research institute, and the suspension lasts for 10 days. And after 10 days, we can expand to 20 days. And 20 days is beneficial to the rights holder. But from the perspective of importers, 20 days is very costly for the storage at the container yard. So during the suspension, the rights holder need to give us the opinions as soon as possible. And if you need to provide the experts' opinion, then like then the examiner should provide us the quick findings, and the cost is also high. And if possible, the rights holders please be proactive in identifying and confirming the infringement. And the enforcement during clearance process is quite special for IPR disciplines, because we have operation prior arrival of goods, during clearance of goods, and post clearance. And we need to do the inspection and supervision during clearance of goods, because at this time, we still have the goods at hand. And because for post clearance, goods might be circulated in the market, and we do not have the ground for further inspection. And during clearance, you can see on the screen the procedure. First is the declaration, and based on the declaration of the custom declarant, and we based on the risk indicators, we will identify whether it has the indicators of IP infringement. And if there's no infringement, goods will be cleared. And for suspended consignment over 20 days, and there's no ground to confirm the IP infringement, and in that case, custom, we need to clear the consignment. And this is the new point in the revised IP law. And our database right now is very primitive. We inspect or we can combine two methods, direct method and indirect methods. And we also have risk management profiling, and we have the risk indicators related to IPR, importers, exporters, name of goods, HS code, exporting country, importing countries, routing. And this information help us to develop the database for IPR goods. Besides the documents provided by the importers, and also the custom documents, you can see here what kind of information we will pay attention to when we inspect IPR goods. It will be reflected in the custom declaration, importers, exporters, name of the good, label, packaging, content, and routing. And trademarks is very important, right? When we talk about the IP infringement, we talk about the trademarks, but there's a limitation from the custom authority. And I would like to be honest with you that even though the requirement of the custom that the trademark uh, shall be declared. But importers, when they file the declaration, they will say like no trademark, or trademark is foreign name, and it's very difficult for the custom officers to get the information and to do risk profiling, because unless they declare, for example, like the trademark is Honda or Chanel perfume, then we can have the sense of suspicion together with other indicators. But if they don't declare this, then it's hard for custom officers to do. And why custom authority cannot identify, or the identification is rate is not high, is because we face this kind of difficulties, and businesses usually make complaints to us that if they are not under the list of legal importers, exporters, then custom usually suspect, or it's not a suspension, but usually have the inquiry and ask the importers to clarify. And I have to be frank that the list of importers and exporters is one of the risk indicators, and if we have the list of suspicions importers and exporters, and if exporters and importers are not on this list, then we can work with the rights holder or representative of the rights holder to see whether they belongs to the list, or whether they on the updated list that custom we are not aware of. And then from there we can do analysis, because there's a case that they can import goods in parallel, and it takes a longer time for us to process the documents. And for Article 125 of IP law, and we talk about the parallel importation of goods and custom, we have to be cautious about goods imported by entities that not on the list of legal importers and exporters. And as I say, suspension, I talk about the time frame, but please look at the 3 stars on the screen under the new regulation. For the third star, that custom proactively suspend, and with the request of the rights holder, then we can suspend the clearance. There might be potential infringement, then we can contact the rights holder, and the two sides we can work together to suspend the clearance of the shipment. And the authority for sanction, and Mr. Chien already talked about that. And we have the Decree 46 revising Decree 99, and it stipulates, and here we have Article 6, 9, 10, 11, 12, 13, and 14. And we can impose a sanction and rights of the holders. You need to file the application together with us to take sample, provide the additional documents and evidence, and respond to custom quickly to address the case fast, to avoid damages for stakeholders or interested party. Now it can be and like the goods owners, and can also use the evidence to refute the like the alleged they to refuse the claimant. And then also for the rights holder, please study legal documents requirements for the application dossier to make sure that you do not have to go back and forth. And please work quickly with custom, and also work with custom in training in distinguished counterfeit and genuine products. And we also have a public service portal. Instead of paper-based documents, you can submit the e-papers, and it's implemented since 15 November 2023. And annually, we also have the plan for risk management. We identify the risky goods, the risky routes, and like the targeting business, and also targeting areas. And annually, we have the training for so together with other competent agencies from the government, we also work with the rights holder. We also organize the regional or international workshop to catch up with the trends in the world. For example, like we just work with the WCO, the World Custom Organizations, to combat the counterfeit goods. It conducted 20th June to 31st June, and we seized 3 cases, and they are added to the database of WCO, and it's called eSendCom platform. And we uploaded the information to that platform, and we also work with 21 custom authorities in Pacific, Asia Pacific, and you can see that we also have regional cooperation. We also improve our capacity, and then we can exchange the work with the foreign custom authorities better. And we receive more than 390 applications, including the domestic and international marks. But there are a few applications from Vietnamese trademarks. It's mostly the foreign trademarks. And in the last 2 days, when I visit the stores here with the GI, and I don't see any GI register with custom. I only see the Martin Spirit already registered with custom, and we can see that Vietnamese marks. You haven't paid enough attention to your marks. So I believe that when you work with the GI, then you need to pay more attention to this, and you can work with the custom to protect your rights at the border. And like I said, we have some statistic on seizures through the cooperations. We have the training, and we also one of the 7 agency to work on the IPR combation and then combat. And like I said earlier, the challenges, we still lack of the electronic database. It's not because we have poor training, but that is the characteristics of the custom authority, because we have to rotate the personnel. And after 3 years or 4 years, one officer will be rotated to another unit, and it's very hard to do the training because the newcomer, they have no knowledge about IPR, and that's why they still have limited knowledge in addressing those IPA cases. And in some urgent cases, we sent the official letter to relevant agencies, but during the suspension we don't get the response from those agencies, uh, because we still have the pressure to clear the goods, but if we have to clear the goods, why we still have the suspension? Even though, like, after the goods is cleared, we still have the market surveillance forced to work on that. But of course, as custom officers, we don't find no, it's good to clear goods when we still have something in mind like that, right? If you go to the border to Lacson, or so, like, the people, they import groceries, consumers goods together with other goods. So that's why our inspection works is also very challenging. And also, like the border residents, they can carry goods across the border, and it's very difficult for us to identify the border residents to bring goods over like that. And there are also other challenges. For example, like the booming of cross-border e-commerce. Even though custom, we do not have the separate policies for e-commerce. And the supervision of goods is still challenges. For now, it's only applicable for goods transported via express couriers. And awareness is also another challenge for us. And hopefully, uh, you can understand the challenges faced by custom, and please be aware of your rights and benefits, and please work with us so that we can enforce IPR better. Thank you.